Ever wondered how major AI companies train their AI models using online data while navigating intricate copyright laws? Stay tuned as we explore their approaches in today's episode and their legal implications. Hello Namaskar, welcome to MindSync's weekly Wednesday podcast, Your Compliance Card, where we dive deep into the world of compliance. As Wednesday arrives, so do we, with deep insights, engaging discussion, and a fresh perspective about compliance and law. Some of the world's largest tech giants, including OpenAI and Google, have been utilizing transcripts from YouTube videos to train their powerful AI models. But wait, isn't this violating creators' copyrights? According to a recent report from the New York Times, OpenAI speech recognition tool Whisper transcribed over 1 million hours of YouTube content, feeding it into ChatGPT-4. Google was allegedly doing the same to build datasets for its language model like Gemini. Now you might be wondering, how does this affect compliance and copyright law? Well, let's break it down. AI models like ChatGPT rely heavily on training data, which often includes copyrighted material. This raises concerns about infringement both in terms of AI's input and outputs. To tackle this issue, companies like OpenAI has introduced measures like Copyright Shield, providing legal defenses and cost reimbursement for business customers facing copyright claims. But what does the law say about AI-generated content and copyright? According to the US copyright laws, work created solely by artificial intelligence, even if prompted by a human, aren't protected. However, the use of copyrighted materials in training AI models is generally considered fair use under certain conditions, but pending lawsuits can change this landscape. The legal intricacies deepen when we consider AI-generated content. While AI systems can't be considered authors, their outputs are often a accumulation of human-made work, raising questions about ownership and creativity. Now let's turn our focus to the landscape of AI copyright laws in India. While countries like United States have begun grappling with the legal implications of AI-generated content, India feels itself in a crossroad with legal and policy proposals yet to be introduced. Unlike the broad fair use exception in the US, India's fair dealing provisions is narrower and doesn't explicitly cover training AI models. This legal ambiguity leaves developers in a precarious position, unsure of the legality of using copyrighted materials for AI training purposes. Despite call from industry players, including Digital News Publisher Association, for specific measures and clarity, the response from the Indian government has been mild. Minister of State for Industry and Commerce, Som Prakash, maintains that existing copyright laws are sufficient, urging users of generative AI to obtain permission from creators. Additionally, Minister of State for Electronics and Information Technology, Rajiv Chandrasekhar, has acknowledged the significance of the copyright issue in AI. Despite the recognition, former dialogues on the matter is yet to be materialized in the country. As we navigate the evolving landscape of AI and copyright, it's evident that collaboration between industry, policymakers, and creators is essential for shaping a fair and sustainable future for AI innovations. That's all for today's episode of Your Compliance Card. Thanks for tuning into MindSync's podcast. If you found this episode informative, don't forget to subscribe for more updates on the world of compliance and advisory services. Until next time, stay compliant, stay informed.